As we discussed in our first session, instilling ethical behavior in court professionals is vitally important. Ethical behavior promotes our commitment as court professionals to impartiality, equity, fairness, and integrity. The question is, how do we impart the importance of ethics in the age of COVID-19 with almost no face-to-face meetings? I'm Pete Kiefer, and I'm here with my co-host, Carl Tanis. Now, usually, along with Judge Sabers, we present highly interactive in-person presentations using audience members as characters to depict ethical situations. We then facilitate lively discussions on the ethical implications. Well, today we're going to recreate that interactive experience using NACM's ethics core curriculum in a virtual environment. We're presenting two scenarios in this second session. And for those of you who are with us on the first session, the good news is that these are two completely different scenarios. After each scenario, we invite court professionals to discuss the ethical implications. Now, through these scenarios, we cover the core learning objectives, being able to start assessing the effectiveness of your court's ethics code, applying the NACM Model Code of Conduct to topical ethical situations, and being able to evaluate the knowledge and commitment your court has to its ethics code. Now I'm going to turn it over to Carl for his thoughts on today's presentation.
Thank you, Peter. I think the two scenarios presented here today really emphasize and demonstrate how ethics is a dynamic topic. From year to year, we experience changes in social attitudes, in employee attitudes about work and work obligations, generational shifts in attitudes, and as the second scenario in social media in particular demonstrates, technological evolution over time. And so this is, once again, not a topic that's a check the box, okay, we've done ethics sort of area, but one that is dynamic, that we need to continually refresh our thinking on and reflect on what the public expectations are of us and our employees' expectations are. And I think this new delivery method fits that need to reassess very well.
Now, we want to hear from you, so use that chat message option. We'll use your comments and suggestions to improve the scenarios and make them even more timely. Both Carl and I are available to respond to your chat messages. Now, this virtual format may not be for everyone, but if you're open-minded like us, I think you'll be able to immediately see its potential. Our first scenario for the second session involves the relationship between ethics and courts personnel rules. It's called Should We Negotiate Ethics? So, on with the scenario.
There's always been two schools of thought about ethics. One view is that ethics comes from within. It's an internal motivation to do the right thing. The other view is that although ethics may come from within, it needs to be explicitly laid out. In the courts, this usually means that the ethics codes are embedded within the court's personnel rules. But what are the implications of doing that? In this scenario, the Metropolitan Circuit Court has incorporated the NACM Model Code of Conduct into its personnel rules a year ago. So let's visit with Jeff Reichert, who has worked for the court for 28 years. Jeff started out as a jury clerk, but he's now the criminal court manager. Jeff's management style is 1, to be responsive to his judges, and 2, to be demanding of his staff.
Well, I know how to keep my judges happy, and I know how to keep my staff on their toes. Yeah, once in a while, one of the employees has to work a weekend or two to get a project out, but that's just the price they pay to keep my court running efficiently.
The Honorable Alice Fair is both the presiding judge and the drug court judge. Drug court has always been close to Judge Fair's heart.
My good friend Nick DeWiley, CEO of DeWiley Treatment Centers, has a new drug that reverses the effects of fentanyl. He asked me how many of our drug court participants have ever used fentanyl. I asked Jeff for statistics going back a couple of years on fentanyl use by drug court participants. When he has time, no rush.
I told my business analyst Paige that I wanted the stats on fentanyl use going back 3 years, on my desk first thing Monday morning. Today's Thursday, so she's got plenty of time.
Paige is the fourth business analyst the criminal court has had. The last three quit. Paige thinks Jeff is abusive and treats his employees like his personal minions.
The drug court doesn't keep statistics on participants' drug of choice. I'm going to have to review each case intake report to identify what their drug of choice was. All 483 reports. Mr. Riker, my boyfriend and I made plans to go camping this weekend. We've been looking forward to this outing for months. I can complete your request by this time next week.
Paige. You know, the fact that you don't have these stats at your fingertips is a pretty serious indication of your inadequate skills as an analyst. A good analyst would have anticipated receiving this kind of request months ago, so it would not have taken him more than a few minutes to compile these numbers. Your lack of planning is not going to look very positive on your annual review, which, oh yeah, is coming up in a couple of weeks. By the way, Paige, I'm not asking you to compile these numbers. I expect them on my desk first thing Monday morning.
Paige tells her boyfriend that the camping trip is off. She spends the weekend at her desk, in the empty courthouse, scouring the drug court participant files.
I looked at all the files. I made a very nice graph showing the drug of choice for all 483 participants. I had the report on Mr. Riker's desk first thing Monday morning. It was then that I found out that Mr. Riker is out the entire week on his own vacation.
Paige goes to Michelle Daniels, the head of the court's Human Resources Department, and complains bitterly about how Jeff Riker treats her. This is not the first complaint Michelle has received about Jeff's abusive behavior. Jeff has been counseled several times before.
Paige, would you be willing to appear at a hearing to talk about Mr. Riker's behavior?
No way. Complaining to you is one thing, but getting the third degree from Jeff at a hearing? Mr. Riker scares me. I'm definitely not appearing at any hearing.
Even without Paige, I'm asking Court Administrator Crutcher to fire Jeff.
Michelle calls Jeff in for yet another meeting on Jeff's personal management style.
Our previous counseling sessions seem to have had no effect. One of your employees said you made them work all weekend with no overtime to have a statistics report on your desk Monday morning. You never bothered to tell her that you were going on vacation yourself. Jeff, you have repeatedly violated Canon 1.4 by not treating your coworkers with dignity, respect, and courtesy. You have also violated Canon 2.7 by not respecting the personal lives of your employees.
Michelle, this meeting's the most blatant example of age discrimination I've ever been involved with. As soon as this meeting's over, I'm headed straight to the Equal Opportunity Commission to file an age discrimination complaint. I want a full hearing, and I have a right to confront Paige, since she's the one who made these insulting accusations against me.
May I remind you that you work at the pleasure of presiding Judge Farrer, so you are not owed a hearing where you get to confront witnesses.
Great. Then I want to personally meet with Judge Farrer. She's aware of the years of loyal service I've given her. She needs to know that I'm the victim of age discrimination. And if I'm fired, I will make sure that I, along with all my Facebook buddies, point this out on social media. That should help her upcoming election campaign. I believe her honors in a tight race with an ex-prosecutor who's running on being tougher on criminals.
Michelle decides to put the process on hold for a week and let cooler heads prevail. When they meet again, Michelle offers a compromise.
All right, Jeff, I'll offer you a solution to make everyone happy. The court will fund your last 2 years of service to your pension so you can retire with the full 30 years.
Well, that is an attractive offer, but I want one more thing. Court Administrator Crutcher has to write me a glowing letter of recommendation praising my long years of service and acknowledging that I always adhered to the highest ethical standards.
Yes, Mr. Crutcher? Uh-huh. I emailed you a draft letter saying Jeff's performance has always been above reproach. You'll sign it? Great, we can get this all behind us.
Before we join my two co-hosts, let's review a couple of the relevant canons from the NACA Model Code of Conduct. Canon 1.4 calls on court professionals to treat litigants, co-workers, and all others interacting with the court with dignity, respect, and courtesy. Canon 2.7 says that court professionals respect the personal lives of litigants, the public, applicants, and employees. Canon 2.8 calls on court professionals to use the resources, property, and funds under their official control judiciously and solely in accordance with prescribed procedures. So let's join my two co-hosts and our panel as they discuss the ethical implications of this scenario. With me are my two co-hosts, the Honorable Susan Sabers, Judge in South Dakota's 2nd Judicial Circuit Court, and Carl Tonnes, Court Administrator for the 2nd Circuit Court, both from Sioux Falls, South Dakota. Our panel includes Alice Roberts, retired administrator for the Alaska court system. Alice played a character in our scenario, but today she's responding as herself. LaShawn Thompson, court administrator for the municipal court in Oklahoma City, Oklahoma. And Barry Lander, retired clerk of court for the United States Bankruptcy Court for the Southern District of California in San Diego. Welcome to you all. I'm now going to turn it over to Carl, who's going to offer some overarching questions that viewers can keep in mind as we discuss the ethical issues of this scenario.
Normally, when presentations like this are delivered in person, we'll pose a question and invite the participants to vote. We would, in this format, that sort of voting is not possible, but we would still pose a question to, as a way to perhaps frame the issues that arise in a topic like this, and might help the participants and the viewers think through the issues that arise and the ethics questions that occur. The question is, should employees' codes of conduct be embedded in court personnel rules? The two possible answers would be yes, they need to be part of the personnel rules with all the due process and other procedural safeguards that go with that, or no, they ought to or need to be separate from personnel rules, more idealistic and more aspirational and perhaps broader. And with that, then I'd turn it over to Judge Sabers to begin the discussion.
Alice, I'm going to start by picking on you. In our justice system, whether it's the civil world or the criminal world, we're often dealing with negotiations, whether it's a plea agreement in the criminal world or a settlement of a civil case. Here, though, the negotiations are trying to get the court system away from this potential claim. Do you think that rises to the level of an ethical violation? And how do you feel about using this as a bargaining chip in this negotiation?
That's a difficult question to answer, because I can imagine a situation where an employer would prefer to reach an agreement with an employee for the employee's departure instead of potentially subjecting the organization to a costly and time-consuming lawsuit. Reasons for this might be that the employee's misconduct, although undesirable, was not egregious enough to support or warrant a dismissal, or in situations where the employee exhibits a pattern of undesirable conduct or misconduct, the employer didn't adequately document and record that misconduct. Another reason might be that the employee's misconduct involves other individuals, and the organization prefers to reach an agreement for the sake of those individuals, so they don't have to testify at a hearing or trial.
Thank you. Thank you. Barry, your thoughts?
Yeah, I mean, it's interesting because, you know, I come from the federal courts, and we actually do have a code of conduct for judicial employees as well as one for the judges. And it's mandatory. I mean, it's the code of conduct for all federal court employees. There's paragraphs related to probation, pretrial staff, and chamber staff, but generally speaking, it applies to all. And as I was watching the scenario, one of the things that hit me was one of the elements of the code of conduct in the federal code of conduct is this sentence: a judicial employee should be patient, dignified, respectful, and courteous to all persons with whom the judicial employee deals in an official capacity, including other employees and the general public. And when I watched him kind of go off, and then heard later on that there's a pattern, you know, that I could see a path to discipline and termination. On the other hand, when it comes to negotiations, I think we've all been there. where you've had the voluntary resignation instead of somebody being terminated, which I know personnel lawyers raise issues about that tactic, but I think we've all been there.
LaShawn, in this scenario, Jeff seems unnecessarily abusive. And I understand, of course, the scenario is constructed to be illustrative and entertaining in some ways. But as we all know, there are times when we do need to ask court staff to perform above and beyond routine expectations. There are times when we'll need to call on them for extraordinary service. But of course, we always have to do so in a respectful and ethical way. So when those times do occur, how do you draw those lines? How do you tell the difference between asking for a commitment and unreasonable expectations of our employees?
Well, Carl, thank you. Like you said, the commitment versus the abuse. And in this scenario, when we unpack this scenario, Jeff has had a history of this. So when I go back and I look at the deadline, it was real clear that it was not of urgency. Sometimes we have to push through and work through the weekends or work extended hours. But in this particular scenario, the deadline was get it to me when you can. I believe that was how it was phrased. And so to ask our employees to work through the weekend on a matter that is not of urgency, I believe is the difference between abuse and getting the employee's commitment. Now, what he could have done is said, we have this project. Let's say if it was due on Monday, he needed it due on his desk on Monday. Now, not to mention, Jeff was on vacation for the rest of the week, so let's not forget that. But he could have solicited the commitment of his staff. Who's available to work on the weekends? Who can help and push us through this, project, and get the commitment from the staff before he just designated someone that I don't care what you do, just make sure you have it on my desk on Monday.
One element that I noticed in the video, and I don't remember exactly how many analysts had gone through,
yes,
but she was the newest She was the newest analyst, which also might be part of the pattern of abuse from our administrator in the video scenario.
Thanks, Barry. LaShawn, if I could flip this on you, just throw a curveball at you for just a moment. We've been discussing this from the perspective of the supervisor. Do you think Paige had any obligation to push back at all, or is that an unreasonable expectation?
Let's not call it a pushback. Paige was not scheduled to work that weekend. Paige should have felt comfortable enough to tell her supervisor that I have some plans already scheduled for the weekend. I've already had a commitment. I hate to use the word pushback because pushback almost seems like she was resistant to do it, but it was clear that Paige had some plans for the weekend. She should have felt that she could have addressed that with her supervisor without fearing any retaliation or anything like that. So it goes back to Jeff. I don't, in my opinion, I don't feel like the environment that was already created and Jeff's history, and he's on his fourth analyst, allowed Paige the opportunity to express that to her supervisor and ask for some more time. Paige could have, provided a deliverable. Well, Jeff, I understand that this is important, but, is there any way that I'm going to be out of town for the weekend? I'm camping, we have plans. Is there any way I can get this on your desk by Wednesday? And now Paige has bought into the commitment of the deliverable that she can have it on his desk by Wednesday.
Thank you. Good point. I think in order to be assertive, you have to have the comfort level established to enable you to do that. Alice, do you have any thoughts on drawing boundaries between calling employees for extraordinary service when it's necessary and justified and just being abusive and trashing Paige's weekend?
Jeff was not required to produce those statistics quickly. The judge clearly said there's no rush. And so the fact that he pushed Paige after being informed of her weekend plans and insisted that she provide the statistics by Monday morning, he clearly was disrespectful, clearly wasn't an issue of commitment. It was more an issue of power and his control over Paige.
Thank you. Good discussion. It highlights how there definitely does seem to be an ethical dimension to how we exercise our authority and supervision. Judge, do you want to take it back?
Barry, the sense I get about our good treasurer is that his abuse of other employees has grown a bit in reputation and perhaps is well known. So now we're put in a position where we're being asked to write this glowing letter of recommendation for him. Is anyone hurt by that? And what ethical complications do you see there?
Well, one of the things I think was in his negotiation, Jeff's, was to have the letter include, that he was a champion of the highest ethical standards. Who's hurt by it is the court administrator, Kutcher. And because it's going to come back. I mean, he's going to get a job somewhere else, and he's going to do something, and they're going to be at a NACM conference, and the new employer is going to say to him, how could you have recommended this guy? He's abusive. I think there's a negotiation on the letter. Look, we're paying his retirement. We're funding it for 2 years. We're doing all this stuff. I think there's a negotiation on whatever letter they're going to get. And we all know that when we call about an employee and we get a name, rank, and serial number recommendation from somebody they named to call, you know that that's probably a sign of something, versus somebody who will freely talk about somebody.
But how about Crutcher as a court administrator being put in this difficult position of he has to protect his judge who's apparently coming up on re-election, and it's almost a blackmail scenario. What is Crutcher to do?
That's a challenge where I'm glad my career ended up in the federal courts. Although working for bankruptcy judges, they do have a term. And I do know bankruptcy judges who were not reappointed because of, let's say, lapses with attorneys and others in behavior in the courtroom. So it does happen there. Not necessarily for an Article III judge. But yeah, I recognize the hard place he's in. And seriously, you could come up with the words. I think, we're all, in this business, we're all sort of wordsmiths. And I think you can come up with words that Jeff would accept along with 2 years funding to his retirement. That would be acceptable without going so far out on the limb that it's going to bite him in the butt later.
LaShawn, what are your thoughts on writing this letter of recommendation and the ethical implications of whether or not to do that?
I stand on the stance that no, we should not write this glowing recommendation. I, too, like Barry said, he may, we don't know if this is the end of Jeff's career. We don't know if he's going to go to another court and take the same behavior with him. We have to have confidence in our legal staff, as far as, my labor relations attorneys. And so if I'm going to make a decision because I have just cause that a person has violated policies and procedures, and I have a history of disciplinary actions against this employee, I have to be confident enough that if we're going to give him 2 years of, for his retirement, and he's going to, sever his ties with the city, we have to be okay with the fact that he may seek recourse. And that's what our attorneys are there for, to assist us in situations like that. I don't think we should be pressured by the fact that he's going to, jump into some campaign issues and things of that nature and sway some votes. I think we have a duty to protect our employees. We have a duty to ensure that discipline is addressed accordingly, and we shouldn't violate any of our personnel policies or procedures just because Jeff is pushing the envelope that he wants this glowing recommendation. He did not leave the organization glowing.
Thank you, LaShawn. Alice, anything you'd like to add?
I would just echo what Barry said about the fact that, when you write a glowing letter of recommendation, there are potentially consequences to that. And if Jeff gets a job at another court, that court is then left to deal with the same abusive patterns that were evident. So,
Judge Sabers, what are your takeaways from this discussion?
Well, I think I have several, Peter, and one was hit on beautifully by LaShawn. This is what we have lawyers for. In every state, no matter what they're called, and I think LaShawn referenced them as her labor relations lawyers. I think they'd be called something different in many states, but this is a phone a friend situation. Before you make some agreement, either to write the letter or to use court management funds to fund this retirement, basically buying off this employment discrimination claim, you have to be talking to your lawyer. But then I also think of Canon 1.2, and if I'm the judge and effectively I'm in a position where I'm worried about my campaign and I need to get this thorn in my side effectively bought out, I'm thinking of Canon 1.2, and I don't think this is simply an appearance of impropriety. I think this is impropriety. If I support this plan of action, I'm supporting the payment of court funds to essentially a cranky employee who's going to make trouble for me in my upcoming campaign. And boy, if the press got a word of that, they'd really love that, wouldn't they? So as a judge, I would absolutely back out of this, make sure I'm no part of this, and my court management would need to be talking to our lawyers and making sure that they've stamped the approval on this. And as far as letters of recommendation, more and more in the employment world, we're seeing them go by the wayside. Oftentimes employers will simply confirm dates of employment and very little else. And I think at the onset of those policies, people thought that meant there were some deep, dark secrets that we were hiding in employment and personnel files. But really, that's not what that means. That means that a policy decision's been made that we won't give out glowing or non-glowing letters of recommendation. And there's certainly some safety in that. So again, I think you phone a friend, as LaShawn suggested, you talk to your lawyers before you agree to write the letter or before you agree to expend those funds to fund that 2-year retirement.
Carl, what are the points that impressed you the most?
Thanks, Peter. You know, at the beginning, we posed a question or a vote about whether ethics codes should be embedded in personnel rules with all the due process that comes with it, or whether they should be aspirational and idealistic and separate. My natural inclination is always that they should be aspirational and idealistic, and we should uphold all those ideals individually and personally and for the sake of the organization and to fulfill our public duty. But as Barry said, we've all been there. We've been in situations like this where we have to balance those ideals against expediency. I asked a relatively new staff person who hasn't been working for the courts very long at all what he thought of the scenario. He thought Jeff was extorting the court. He thought the HR director was paying off the extortion and giving him protection money. and he thought that the recommendation letter was just plain dishonest and a step beyond. And so when I consider that perspective of a fresh employee who's not spent time in the courts, sometimes that brings me back to one of the ethics tests that I always apply. If I went out to the sidewalk in front of the courthouse and tried to explain this to a member of the public, what would their initial reaction be? And I think that's a good way to evaluate some of these ethical questions.
I want to thank my two co-hosts, Carl and Judge Sabers, and our panelists, LaShawn, Alice, and Barry, for sharing their opinions today on the ethics of this scenario. I'm Pete Kiefer, and thanks for watching. The characters, organizations, and situations depicted in this scenario are fictional. Any relation to actual individuals, organizations, or events is purely coincidental.
Our next video explores the relationship between social media and the courts. It's called, Can You Speak Your Mind on Social Media? So on with the second video.
How quickly times change. It wasn't just a few years ago that talking about social media meant talking about Facebook and Twitter. Well, to some of us it still does. But now there really are a host of different social media platforms available. This raises ethical questions.
How much investigating into an employee's social media presence can a court do before that court starts to look like it's cyberstalking?
So let's meet Riley Williams, who is a supervisor for the Metropolitan Circuit Court. And she is the obvious choice to become the new criminal court manager. Riley is also an ardent user of social media to express her opinions.
I've only met Court Administrator Crutcher twice, but I know he and I are on opposite ends of the political spectrum.
But Riley, why tempt fate and your job by posting inflammatory statements on social media?
I have a right to express my opinions on the state of society so long as I do it as a private citizen.
Riley created a nondescript virtual profile called Riled Riley. She's careful never to mention the word court or her job in any of her posts. Well, Riley may think that she's been devious, but maybe not devious enough to avoid detection by Court Administrator Max Crutcher.
Well, I was recently told that one of my criminal court supervisors, her name is Riley Williams, she's been posting inflammatory messages all over social media. Yeah, this is inappropriate for a professional who represents the court. Well, yeah, fine. Well, look, after the fiasco you created with Buck Riker, I am completely capable of counseling one of my own employees by myself. Thanks a lot.
Riley gets a call to come to Mr. Crutcher's office. This cannot be good.
Now, Riley, I understand you've been posting messages on social media that are unbecoming of a court representative.
Mr. Crutcher is such a fossil. How does he even know about my personal postings?
Let's just say that I'm pretty savvy. I keep a keen eye on all social media. First, I am ordering you to remove your Facebook postings and turn off your Twitter account. Then we will talk about whether the court even has a place for you moving forward.
Mr. Crutcher, I am way ahead of you. I do want to apologize for any offensive Facebook postings and let you know that they have already been removed. I do invite you to check my Facebook site and let me know if there's anything left in that you still find inappropriate.
Well, I'll do just that, okay, Riley?
Riley is winking because she doesn't have a Facebook or Twitter account. She uses a social media platform called 4chan. A week later, Max orders Riley back into his office, and he is not happy.
I see that you have not removed the inflammatory posts that I asked you to remove. So can I assume that you've been lying to me all this time?
Wait a minute, you asked me to remove all my inflammatory Facebook posts. Well, I'm not even on Facebook or Twitter, so I did exactly what you asked me to do. Furthermore, I am the one who's going out of my way to follow the personnel rules.
All right, stop playing cute with me. All right, it wasn't Facebook. I've got, what is this? This thing, it says, there's some app that you're on, it's called 4chat.
4chan.
4chan, what?
4chan, it's called 4chan, not 4chat.
All right, whatever it is, all right? The point is that these posts are still there. I've seen them myself. I want your employee badge. Jeff Riker, you know Jeff, right? He's security. He's our security head. He's coming here. He's right outside the door. He's going to escort you out the building.
Whatever you think I did, and I'm still not admitting to anything, what I did is in compliance with the court's personnel rules. Canon 4.1 says that I am to engage in political active strictly as a private citizen. I did just that. I went out of my way to make sure no one knew I worked for the court.
Well, I figured it out.
No, you didn't. Somebody ratted me out, and I'm pretty sure I know who.
Yeah, well, it's none of your business to try to look into who did it. Doesn't matter how I figured it out. I want your badge, your keys, and your assigned smartphone, all right?
Okay, but it wasn't me. All posts in 4chan are anonymous, so I deny ownership of any post that you claim I posted.
Anonymous? Okay, look, Riled Riley, I don't need to prove anything. You work at the pleasure of the appointing authority. The presiding judge and I do not need your services any longer. Besides, if 4chan, whatever it is, if that's anonymous, then you really should stop using that stupid moniker, Riled Riley, at the bottom of your posts.
Riley is escorted out of the courthouse. A week later, Max announces some personnel changes that surprise Paige Pascal.
Paige, hi. Max Crutcher, how are you? Yeah, congratulations. You're the new criminal court administrator.
Before we join my two co-hosts, let's review a couple of the relevant canons from the NACA Model Code of Conduct. Canon 4.1 calls on court professionals to engage in political activity strictly as private citizens and only in accordance with federal law, state law, local court rule,
and policy of the appropriate local governing authority. Canon 1.2 states that court professionals avoid both impropriety and the appearance of impropriety, including improper influences that would impugn the dignity of the court.
So let's join my two co-hosts and our panel as they discuss the ethical implications of this scenario.
With me are my two co-hosts, the Honorable Susan Sabers, Judge in South Dakota's 2nd Judicial Circuit Court, and Carl Tonnes, Court Administrator for the 2nd Circuit Court, both from Sioux Falls, South Dakota. Our panel includes Alice Roberts, Retired Administrator for the Alaska Court System, LaShawn Thompson, Court Administrator for the Municipal Court in Oklahoma City, Oklahoma, and Barry Lander, Retired Clerk of Court for the United States Bankruptcy Court for the Southern District of California in San Diego. Welcome to you all. I'm now going to turn it over to Carl, who's going to offer some overarching questions that viewers can keep in mind as we discuss the ethical issues of this scenario. Carl?
Normally, when we conduct sessions like this in person, as opposed to this virtual format, we'll pose voting questions and ask the attendees to vote to get a sense of the room and a sense of people's minds on certain topics. In this format, we'd ask you to consider a question and your response as a way to perhaps frame this or think about these issues as we go forward. The question is, should courts be investigating all social media platforms for employee opinions and participation? And the possible votes, if we were in an in-person format, could be yes, courts need to actively investigate and monitor social media platforms, be proactive in other words, or no, courts should generally be reactive and act only when an employee's social media activity comes to the attention of the court. And with that, I turn it over to Judge Sabers to begin the discussion.
And LaShawn, I think I might start by picking on you here, so get ready. Folks, so I think we're dealing with two different issues here. On one end, we've got a canon that says we need to respect our employees and respect their personal lives. And on the other side, we've got canons that repeatedly say we need to make sure we're avoiding the appearance of impropriety. So here we've got a young employee of the court, and at least someone is objecting to the things she's posting. LaShawn, how much digging do you think a court should be allowed to do to keep track of its employees and their social media habits?
Thanks, Judge. This is a tough one to unpack. So how much digging should a court be allowed to do to keep track of their employees and their social media habits? First and foremost, we should all of our employees should have been trained or understand the policies and procedures around their social media accounts. As a court employee working for the courts, there are some things that you do give up by becoming a court employee. And I think that should be really clear, and that should our employees should understand that. Now, when we talk about the courts itself digging into the background of our employees, I think that that is not a good use of the court's resources to investigate our employees. If we have some concerns about our employees, we should report that behavior to either our ethics department, if you have one within your organization. We do have one with the City of Oklahoma City, or you turn that matter over to human resources. But from a court's perspective, I don't think we should use our resources to dig and probe into the background of our employees' social media accounts. We should set clear expectations about their professionalism. We should set clear expectations about any infractions or whatever the discipline will be if this behavior is unbecoming of a court employee. But to use the court's resources to investigate, in my opinion, is not a good use of our court's resources.
Thank you, LaShawn. Barry, once again, we've got respect their personal lives, and we've got avoid the appearance of impropriety. How much digging can we do?
Well, I think one thing we've got to be aware of, and I know we're talking about the canons, but I think when you apply the canons in the personnel environment, you've got to have the rules stated, for lack of the policy stated about what you will and will not do in terms of investigating. from the standpoint of social media, the federal judiciary has some guidelines, and it doesn't mandate a policy. It mandates, what policies should include and consider. And one of them is whether you're going to do exactly what we're talking about here, whether the policy will require access to an employee's social media activities, including those that aren't public, for purposes of investigation, whether you're going to alert the employee. There are some things from a personnel standpoint that has to be sort of included if you're going to go down this path in terms of at least policy. In terms of the ethical aspects of this, I think there's a question of whether the kinds of things she's posted are proper, inappropriate, and whether they reflect back on the organization appropriately. But I think up front, you've got to be clear as to employees as to what the expectations are when it comes to their employment. And that's true for so many jobs, not just with the judiciary.
Can we stop there really quick? Barry, you said that raised issues about the work environment, but I didn't catch that in this scenario. What he said was just inflammatory comments. It's come to my attention that one of my employees, my criminal supervisor, has posted inflammatory comments, but he doesn't describe what kind of comments.
But Alice, I think your point is an excellent one, because there's a difference between what Riley's saying. If Riley is commenting on the courts, commenting on her boss at work, commenting on perhaps his political positions, if that's the substance of her post, that's a different deal than if she's posting that she's cranky with her boyfriend, right?
Yeah, Alice, I think this is a really important angle that frankly I hadn't considered. When I played this for my new kid, one of his reactions were, they keep talking about inflammatory comments. What are they? And I think you put your finger on it, because it makes a big difference. If he's disparaging the court or the supervisors or sort of internal fetching, yeah, that's one thing. But if he's talking about, if she's posting about Harris, Biden, or Trump, Pence, that's another thing. If she's posting about court cases that come through the courthouse doors, that's another thing. So I think the content of those inflammatory comments, whatever that is really important. Alice, can I pose a question to you about the comments themselves? Do you have any thoughts on how we may handle this situation differently or think through this situation differently depending on what the nature of those comments are?
Well, one of the things that struck me in this scenario is that the only mention is of inflammatory comments. We don't know what they're about. We don't know if they're comments about the court and its management of resources, a court case, or if they're simply comments about the recent political election. If Riley posted something about the court that puts the court in a light that citizens that fall within the jurisdiction of the court would not have confidence in the court's ability to hear cases in a neutral manner, then the court, I think in this scenario, has cause to take significant action to resolve this issue. But if Riley is simply commenting on a matter that the local community is talking about as a private citizen, even if those comments are inflammatory, I don't think the court has a place in that scenario to act.
I'd like to offer an example that happened to me in real life. I was handling arraignments one morning, and one of the prosecutors was clearly disappointed in my bond decisions, thought that I was reducing bond too frequently. And the next morning when I came to work, one of the other staffers said, "What did you do to so-and-so yesterday?" Well, this prosecutor had posted that she was very disappointed in the bond decisions. She hadn't listed me by name, but she had made it clear that it was bond rulings and it was very easy to tie back to me. And she said something to the fact that she missed those days where the court was fair to both sides of the equation. Well, of course, that should be off limits, and she shouldn't have done it, and we knew this. So what to do about it? She's not under my, she's not one of my employees. She doesn't work for the courts directly. She's a member of the state's attorney's office, our local prosecutor's office. whether it was good or bad, I picked up the phone, I called her boss, who's a friend, and I said, hey, this was posted. I don't care, but someone somewhere will, and someone is going to take exception with this and think that it reflects poorly on the courts. And I would encourage you to encourage her to remove the post before it gets more widespread, before the folks looking at it really recognize what it is. And he did, and the same employee who told me about it told me it was down the next morning. So it doesn't have to be a huge deal. Here I get the sense in our own scenario that this is a bit of a personal grudge between these two. Embedded in the facts, the young woman says, well, I don't know him well, but I certainly know we're on opposite sides of the political spectrum. So my guess is the boss is saying a few things that she disagrees with politically, and that's probably what's fueling this. But there are so many easy and quick ways to cut this off before it gets worse. Right. You have to be willing to work with the employees at that level and say, hey, we need to take this down, and this is why. Of course, if that same prosecutor had posted about a fight with her boyfriend or an argument or a good or bad movie, no one would have had any complaints or anything to say. So the substance of what is said and whether it reflects directly back on the courts is a huge part of our analysis. And I think we need to start there. And I really appreciate that comment, Alice.
Barry, here in South Dakota, we have a state statute that says all state employees, which would include court employees, enjoy all the rights to free expression and the First Amendment as any other citizen in the state. On the other hand, if I want to moonlight, no matter what the moonlighting job might be, after hours, that request goes all the way to the Chief Justice because it has implications and possible reflections on the court. I mentioned those two extremes as an illustration that even here, we're in sort of a gray area about court employee boundaries and degrees of freedom and the rights we may set boundaries upon when we begin our employment with the court. In general, do you think that we're explicit enough with employees? Do you think we make it clear enough to them that when they come to work for the court, we may set boundaries on some of their behavior after 5 o'clock and outside the courthouse doors?
Yeah, going back to codes of conduct, they do govern, depending on how you're incorporating how mandatory they are, activities both workday and after work. They do reflect some non-work hour requirements. So when we talk about social media, we talk about guidelines for use of social media, which a lot of courts have adopted, a lot of workplaces have adopted. I think if you tie back to those codes of conduct, I think that's an important part of dealing with this issue of the First Amendment, the rights to express views. There are typically related to elections. I can tell you right now, as Peter said in the introduction, I recently retired. I've spent 40 years in the federal courts. I have not been involved in partisan political activity. That is a prohibition. I am struggling right now to figure out how to suddenly engage in a world that I have been basically maybe using my old job as an excuse to not engage in, but publicly be involved in this. I was volunteered for an advocacy committee, and I find myself on these calls listening because I'm not sure I'm ready to advocate because I've spent a career not doing that in a partisan environment. Well, those kind of rules are reflected in social media these days. And so I think that providing some guidance to staff is important. That is part of the hiring process or part of your orientation for a new employee coming on board, as well as new policies when they get rolled out, whatever training you do on those in your office. Like I said earlier, if you're going to do something in this area, you want to be upfront. This is back to the personnel lawyer thing. You want to be upfront about what monitoring you're going to do, especially at work when people are on their computers, and now work currently is fairly remote for a lot of people. So they probably are juggling work and their Twitter feed at the same time, not that they would ever do that at work. And just as a side note on that, one of the things we learned in this scenario, naming names in a policy or a guideline of what technology is or isn't okay. Like a policy that says when using your court modem, things change quickly. So naming Facebook, naming Twitter, he got into a spin on that one where he said, remove it from Facebook and Twitter. Well, it wasn't on either of those. So therefore I did what you asked, which is nothing.
Thank you. You know, your comments, and especially in this election season, bring to mind that my employment with the court is really helpful when candidates knock on my door and ask for contributions. It gives me a very helpful way to wave them off. But LaShawn, if I could go to you, do you have any thoughts on whether we make these boundaries clear enough to court employees, whether we make it clear enough to them that their outside activity can indeed be a reflection on the court in many ways, or give some members of the public and some litigants some pause on whether they can be treated fairly when they walk through the courthouse doors?
I think we owe it to our employees to be clear, place them on notice in regards to our expectations and of their actions. We have to be real clear, because how can you take any action on an employee if you're not clear about the expectations of, being a court employee? And you have to tie it back into those pillars of justice so they can understand how their actions impacts, somebody's views about the court system. If you're posting something on social media and then you may say, oh, I was sitting in court, I overheard a decision that maybe, a judge made in court, and I didn't agree with it. You post that on social media. Now you have some defendants that are scheduled to be in court tomorrow, and now their views are distorted about what the ruling is going to be maybe in their potential case. So as court employees, we have to continue to build upon that trust and that confidence of our citizens. And that's something that we have to do a good job of communicating with our court employees about their professionalism and how it ties into the nature of the court system. And so the answer to your question, do we do a good job? I think we can do better, and it starts with explaining to our employees how their actions tie into our daily operations of our courts. Again, it goes back to that trust and that confidence, and that's something that we have to maintain, and we hold that in high regards.
One of the things that we've grappled with this issue in the Alaska court system, specifically with regard to Facebook postings, and I recently helped create a program on the primary topic confidentiality. But our approach in resolving this issue, we had some, bad posts to deal with, is let's hit employees on the front end and not just talk about what employees shouldn't be doing or should be mindful about not doing on social media, but really talk to employees about the reflection their posts have on themselves and their career in the court. Because if we hit employees on the front end when they come through the door, we talk about why what posts can do from a perspective of the court, and the citizens and their impression of the court, but also from the perspective of the employee and what supervisors think about the employee. It reflects on them professionally. So,
and Alice, I think that's a really important point, because removing things from the internet is, yes, you could hide a post that you put on Facebook or delete a tweet, but we've all seen the deleted tweets come back to haunt people. And so removing is so difficult that the more work we do up front, I think is what pays off when it comes to protecting our employees from themselves, which I know seems like a silly statement, but it is what we're doing here.
Right. And you're right, from themselves, because it reflects on them for future employers, not just even the current employer.
So Judge Sabers, what are your takeaways from this discussion?
Well, several again, Peter, and I think at the end of all of our discussions, everyone has said sooner or later, this was a tough one. And I think, again, we've got a scenario which is a tough one. We have We need at all times to avoid the appearance of impropriety. We need to honor the confidentiality of what we do within our buildings. But as a practical matter, what we do outside our building sometimes does reflect on what we do inside the building. And when it reflects poorly, we need to deal with that. And I think what we've heard from both Barry, Alice, and LaShawn, telling our employees up front, you need to pay attention to this. You need to make sure that what you're doing outside is not reflecting poorly on what you're doing inside of our building. And we need to warn them about that and make those rules clear at the beginning of their employment, instead of waiting for the objectionable post, which is going to come up sooner or later, and then have them be surprised that we're trying to curtail their free speech. So I think the more we can do up front, the better, and we need to warn our folks and put it in clear terms to make sure that we're not in a situation where things are reflecting poorly on their work.
Carl, what are the points that impressed you the most?
It crosses my mind, Peter. Here we are more than 2 decades into the popularity of social media, and we're still having these vigorous discussions. And I think we need to, and I think they're still worthwhile. But this time, I go back to what LaShawn said about how do we want to spend our time. I would like to be proactive. I'd like to be active in safeguarding the dignity of the court and public trust and confidence in our impartiality. But as LaShawn said, how do we want to spend our resources? How do we want to spend our time? And at some point, we hit the practical limits of being active. We hit as the internet and social media gets more fractured and splintered and active, and as we deal with even further generational differences in attitudes, we can't possibly keep up, even if we do want to be active. And so I think it's far more helpful, far more worthwhile to do it on the front end with our employees, just as we've discussed, that if we instill those principles on the front end, then we don't have to be the internet police. Not that as a practical matter, we ever could be. So I sure thank the panelists today. It always is a worthwhile discussion, and I thank you for your thoughts. And every time we do one of these discussions, I go away thinking that was a really good use of time, and I wish we had more time on this one.
The characters, organizations, and situations depicted in this scenario are fictional. Any relation to actual individuals, organizations, or events is purely coincidental. We hope you enjoyed the 2 ethical scenarios. But more importantly, we hope you can see the potential for using videos like these to inspire thinking about ethics in an age of telework and Zoom meetings. Another real plus is being able to have court professionals share their insights regarding these ethical situations. These scenarios can be used in pre-recorded sessions that a single person can watch at his or her convenience. They can also be a component of a virtual program, such as a live webinar. And finally, they can also be used as a video component of a live face-to-face learning environment. In a webinar format, a facilitator can use the live polling and chat options to enhance audience interaction. In a face-to-face environment, the facilitator can simply pause the video when he or she wants to engage the audience in a discussion. Just imagine an entire library of scenarios covering an array of topics. And the good news is that you'll be able to simply download the scenarios if your court or state association wishes to use them. I'll turn it over to Carl for some final thoughts.
Thank you, Peter. You know, I mentioned previously that I do miss the energy and spontaneity of a breakout room and at a hotel conference. On the other hand, how many times have we been in ethics sessions, rich, energetic ethics sessions, and a topic or a question comes up that we would dearly love to follow, but we simply don't have the freedom under the constraints of time to follow those topics? How many times have we been in a live session and thought to ourselves, this may not address each jurisdiction's considerations and constraints and particular individual environments? This format, even though it may be constricted in some ways, actually in other ways gives those responsible for training and development and ethics for court employees a great deal of freedom and discretion. They're able to go down those avenues, to pursue those points, to tailor this content to their particular jurisdictions. And so even though this is a new format, a new delivery method, we hope that it does give those responsible for training in many ways a great deal of freedom and discretion and ability to tailor content in a new and dynamic way.
And as we said, we want to hear from you. Your comments and suggestions will make these scenarios even more timely in the future. I also want to thank Judge Sabers, Carl, our panel of respondents, and our courageous actors. They were all very brave in agreeing to appear in these videos. I know I speak for Carl in saying thanks so very much for watching.